Good morning, distinguished conferees. You are welcome to day 3 of the annual Criminal Law Review presented by the Rule of Law Development Foundation. And you will all agree with me that we have had 2 very action-packed days. And by the grace of God, today will not be an exception. Yesterday we discussed criminal procedure and also then delved into the unlawful criminalization of freedom of speech. Now, today we'll be looking at a very important aspect of the entire criminal law discourse, which is evidence. Distinguished audience, you will all agree with me that without evidence, the prosecution cannot properly prove its case before any court. Those who are doing investigation also require evidence. And today we'll be looking at it from 2 perspectives. Today, this morning, we'll be looking at electronic evidence, given the fact that we are in the 21st century and we have several devices. Even documents are no longer made in the manual form. So today we have our panel, and our chairman for this session is already seated. He's a partner of the foundation, and he has always come to our aid anytime we need to discuss this topic. I urge this house to give a resounding round of applause to Ahmed Raji, Senior Advocate of Nigeria. He's already seated, and he will be conducting the proceedings. And this year, conferees, you are very fortunate. Your paper presenters are both giving us wealth of knowledge from the bench. Our lead presenter is no other person than Honorable Justice Alaba O. Adileye. He's a formula face. Let's give him a round of applause. He's almost part. He's part of the foundation, and we have definitely looking forward to what new innovations have come this year. And also with us is Honorable Justice Mashood A. Oredola, retired, GCA. He has been with us throughout the entire program, and today finally we hear from him on his perspectives on the topic. I understand that Paul Erokoro SAN is on his way, and in the course of the program he will join us. And last but not the least on the panel is Mr. A.T. Kende, Senior Advocate of Nigeria. Please, let's give him a round of applause. He will also be contributing to this topic about updates and legislative developments in electronic evidence. Mr. Chairman, your panel is constituted, and the time is stated on the face of the motion paper. I so move.
Good morning, my lords. The eminent silks, especially our leader, Mr. David Daudu. There is no doubt the panelist is very intimidating, and when I see Justice Agile's name, I say yes, he's going to be rolling. And of course, my Lord Joseph Oredola, the reputation soars. May God continue to be with you. It's a pity Mr. Erokoro is not coming, or is on the way. But I know Mr. Kande will adequately cover the field. I recognize Professor Akushaye George and all other eminent people present here today. I will not preempt the very robust submissions that will be coming from the panel, especially the lead discussants. But one thing is very clear. Technology is key to the modern world. And the whole issue of electronic evidence was birthed by the advance in technology. And we all know that your case is as good as the quality of evidence you have proffered. You may have a good case, but if you don't put it through the right evidence, you may end up losing whatever it is that you are supposed to have. So, electronic evidence cannot be overemphasized, and it's one that deserves a detailed attention, because in the modern world, technology is changing the way we do things in all ramifications. For example, in the area of taxation, they used to talk about, hey, you have to have a permanent establishment before you can tax an entity. But today, a lot of entities are doing business without having any, they call it mass without scale. That is, they are in a jurisdiction, they are conducting businesses, but they are not present there physically. How do you tackle that? How do you lead evidence? It is through technology. And besides that, we're talking of electronic cars and whatever. I mean, how do you group them? What happens to them? How do you assess them? If a car with electronic devices going on and it has an accident, who is responsible? These are all the issues that technology will have to be contending with in the nearest future. So I want all of us to have an open mind and tackle this topic. We have to join the lead speakers, the discussants, in doing a very good analysis that will help in the development of the law, because it's still unfolding. There is this robot. Robot is now a new dimension in manufacturing and what have you. Question: should robot be treated as a worker, or should just be treated as is it taxable? These are all issues that are coming up as a result of science. So with this, I want to declare this very interesting episode open, so that I'll call on the lead speaker to come and whet our appetite. And as usual, because this is not the first time I'm listening to him, and I know he will do substantial or absolute justice to the topic. Thank you very much, ladies and gentlemen.
Thank you, Mr. Chairman of the session. Let me begin by making an ex parte application that in the event that Paul Erukoro, SA, is not here, permit me to appropriate his own time to my own. Thank you, sir. The chairman of session, Mr. Rajis, Senior Advocate of Nigeria, the coordinator, Rule of Law Development Foundation, Mr. J.B. Daudu, Senior Advocate of Nigeria, my Lord, Honorable Justice Oredola, JCA, retired, Learned Silks, that we have here, my discussant of my paper, Mr. Kehinde, Senior Advocate of Nigeria, my brother and my friend, Yemi Akinsheye George, Senior Advocate of Nigeria, distinguished audience, permit me to stand on, if any, existing protocols. I thank Mr. J.B. Daudu, Coordinator, Rule of Law Development Foundation, for the opportunity afforded me once again, and I say for the fourth time in succession, in leading a discussion on electronic evidence in the annual law review, criminal law review seminar conference of the Rule of Law Development Foundation. I appreciate you, sir. And I acknowledge the dimension this program is taking. I counted the number of speakers in this program, and I was able to count over 60. If you have a program in which 60 speakers can be attracted, I am sure it is by no means a small program. Well, thank God that there appears to be a change in the composition of the panel. When I received the email, the composition actually intimidated me because I found myself in the midst of senior advocates. And I said I was a rose. I was going to be a rose in the midst of thorns. Thank God, Justice Oredola JC is here. And I think I am very comfortable with the panel now. Well, my introduction. We know electronic evidence are an offspring of technological development that the world has witnessed in the last few years. We have experienced some major changes, that is the world, due to advancement of science and technology. And this advancement has affected virtually every aspect of human endeavor. And the court is not left out. The legal system also is not left out in the process of the metamorphosis. Under such circumstance, it is to be required that both the law and the court must cope with the pace of technological development to ensure that justice is done. And we have a particular section of the law in our Evidence Act that takes care of admissibility of electronic evidence because of the advancement in technology. The world too has developed in a way that many materials, many documents being generated electronically will have to be tendered in court. And so we have Section 84 of the Evidence Act 2011, which represents what I call the response of the legislature to enhance effective delivery of justice in a digital environment. So, from the legislative point of view, Section 84 is meant to facilitate admissibility of electronically generated evidence. But I say here that the extent to which this has been achieved is very debatable. And in my paper, I run through the regime of Section 84. It contains what I call detailed provisions, which lay down stringent conditions. I call these conditions stringent conditions for admissibility of documents produced by computers. Section 84(2) consists of 4 conditions that are required to be fulfilled. The 4 conditions are stated in my paper. Then I have to make this point of what the Supreme Court has said about this section 84(2). The conditions, recall, I have described as stringent conditions. Nevertheless, the Supreme Court in Cooper and Dixon, has laid down the basic principle that where those conditions are not fulfilled, a computer-generated document is inadmissible. This is very important point to make as a background to the further points I am going to make. Bear in mind 4 conditions are described as stringent, and the Supreme Court in Kubo and Dixon has said these 4 conditions must be fulfilled. And if they are not fulfilled, then a computer-generated document is inadmissible. Then, beyond that, we have what I am going to call the problematic and the similarly intractable subsection 4. Section 84.4. This section requires the production of a certificate. The law demands that a certificate must be produced to authenticate the computer that has produced that document, and of course the document itself. So the certificate ordinarily is meant to fulfill 2 purposes: authenticate the electronically generated document and authenticate the computer that has produced the document. Again, we have some conditions that will have to be to be fulfilled under section 84.4. Among other things, the certificate must identify the electronic document. The certificate must describe how the document was produced. The certificate, I want to emphasize the next point here. The certificate must give particulars of the device involved in the production of that document. I underscore this requirement. Give particulars of the device involved in the production of the document. This statement will lead to some further discussion as we go on. All these requirements are to show that the document was produced by a computer, and of course there is also the requirement that the certificate must be signed either by a person occupying a responsible official position with the operation of the relevant device or the management of the relevant activities, whichever one is appropriate. So these conditions are required to be fulfilled. Then I bring us to the debate on section 84, and particularly section 84.4. And the question, the subject of the debate is section 84, to be or not to be. By far the most volatile and seemingly intractable provision is section 84.4, which, as I have just stated, commands the production of a certificate to authenticate the computer that produced the electronic document. The subsection has engendered so many questions. The subsection has raised so many questions and brought about so many conflicting judgments of courts, such that the truth of the matter is, we can say we don't even know where we are in respect of this simple provision. Evidence Act was enacted in 2011. We are in 2021, and yet we cannot say clearly that we have decisions that have clearly interpreted correctly the provisions of this subsection. I have raised, or I identify about 10 questions in my paper that have been engendered by section 84.4. So many of them. So, for instance, what form should a certificate take? Another question, who is the proper person to tender a certificate? Another question, who is the proper person to sign a certificate? Who is the responsible officer identified under this section? What should be the exact content of a certificate? At what stage of the judicial proceeding should a certificate be tendered? Should a certificate of authentication be treated as a formal document that is required to be filed at the registry, or just to be tendered as a party's document? Should a certificate of authentication be, what happens to the proponent of an electronic document that has no connection with the computer? And I want to emphasize the 10th question that I ask here, from where I will proceed. Is compliance with Section 84.4 mandatory in a situation where it is impossible to obtain certificate from the competent authority? So what happens? Okay. I try to emphasize the requirement of particularizing or giving particulars of the computer that produced a document. So the question here is, if you have nothing to do with the certificate, how do you supply the particulars? And if the person who has something to do with the certificate refuses to give you that certificate, so what next do you do? I bring it down practically for you to see, because I was confronted with this situation in my court. A bank issues a statement of account to you. The statement of account is disputable. You want to challenge it? Well, let me even give you the facts of what happened in my case, in my court. Somebody took a loan from the bank and liquidated the indebtedness as far as he was concerned. But the bank said, no, you are still owing us. And from source, they continued to deduct his money. The man wrote them letters, protested to them, to the bank. The bank did not yield. Continued to deduct. Continued to deduct from the salaries of the so-called debtor. Ultimately, the man came to my court and challenged the bank. And his position was that I am not owing the bank. And in order to prove that he was no more owing the bank, he had his statement of account, in which it is recorded in the debit side is 0. In other words, that the man was in actual fact, at least from the document, not owing the bank. And yet the bank was deducting his money. So he attempted to tender this document, and the bank's lawyer objected to it. And the basis of the objection was simply that that document was not backed up by a certificate. Well, the man said, I am not the one to produce the certificate. I applied to the bank. He didn't give me. So the issue is now, this document that the man intended to tender, is the court to reject it just because that certificate was not tendered? In the first place, the party, the bank customer, it's not his computer that produced the document. And so how will he be able to give particulars of the computer of the bank in a certificate? So basically the law requires that it should be the bank that should make the document available. So we have all these practical situations being raised under Section 84.4. And I have stated here that by the reason of my position as a trial court judge I've seen so many of these things. Practical situations, practical challenges being raised by Section 84. And I am here today to make a very strong case. Before now, in the past conferences, I have actually, maybe just in passing, made the point that we should, re-examine this Section 84. But today, I am convinced, and I want to make a strong case, that Section 84 is no more serving the interests of justice in our law. And my position is that it should be abrogated. I will give my reasons as we proceed. So, I hereby call for the abrogation of Section 84(4) particularly. And my recommendation, just in summary, is that the subsection should give way to a very simple presumption that electronic devices worked well when they produce affected documents. For instance, in the case I've just cited as an example in my court, if a bank can produce your statement of account and can give it to you, this is the statement of account, there should be a presumption in favor of the bank, of the computer of the bank, that as at the time it produced this document, that computer must have worked well. As simple as that. And if there is any evidence to show that there is going to be a challenge that the bank's computer did not work well, the onus is on the person who says that the computer did not work well, and he has to prove it. So, I have stated here that my approach to Section 84(4) is premised on the basic notion that no law is enacted to hamper the dispensation of justice. Unfortunately, we are proceeding in a way now that it appears to me, and that's why I'm making this call of application, that Section 84(4) regrettably is hampering the dispensation of justice. The enactment of Section 84 of the Evidence Act was meant, no doubt, earlier I have said, from legislative point of view, but I want to assert clearly that that provision was actually meant to facilitate admissibility of electronic evidence and not to hinder it. It is also my view that law, any form of law at all, like nature, should never be static. It must be dynamic. So there is no need that we should pigeonhole ourselves into the provision of Section 84(4) when the world around us is moving on. So there must be dynamism in our law and the application. So the law relating to the admissibility of electronic evidence, I want to make the point, is expected to be a handmaid of justice. Well, it provides for conditions to be fulfilled, but then, from my experience, I've discovered that a certificate under Section 84(4) is no more a certificate is no more than a formal document prepared to satisfy the provisions of Section 84(4). The point I'm making here is that I ask you, after all, this certificate we are talking about, what is the essence? And who makes it in the actual fact? I remember in one of the conferences, I made the point that I know as a fact that these certificates we are talking about, they are documents that are prepared by lawyers in their chambers and to only satisfy the condition because they know the law. The law says there must be a certificate. And so they will sit down in their chambers and prepare the certificate for the client. What I said then didn't go well with the lawyers in attendance. But then, the truth has to be said. That is, if we search our conscience, that is the truth. And this fact was made clear to me, or made clearer to me recently in a proceedings in my court, when somebody put in a witness in a criminal case, and it got to a point, if it were to be in a civil case, maybe there will be no problem. The facts are already contained in the statement on oath. Somebody will just come and adopt the evidence and proceed. But in this case, criminal case, viva voce, all the facts must be stated. The man stated all the facts required under section 84(2), and then he got to the point of the lawyer leading him to tender the certificate. There was no question he did not ask. But the man didn't get the gist. Because, of course, it got to a point, he said, okay, after all this that you have done, what else did you do? Of course, he has to lead, his questions under examination in chief must not be leading. So, he must not mention the word certificate. But the man didn't know that he was leading him to produce a certificate. He said, okay, your computer was working well. This thing, you produced it in the course of your business. And after all this then, what else did you do? The man said he did nothing. I left him to continue to battle. He was battling. So I tried, of course, if we had mentioned certificate, the man was intelligent enough to know what was it. So practically he had problem. And why did he have that problem? Because he had nothing to do with the certificate. Maybe before they came in, question certificate was raised to him, but when he got to the witness box, maybe he forgot. So he didn't remember that it was this certificate that this lawyer wanted, that should be tendered. So the truth is, from the example of that man, he had nothing to do with certificate. So I am making the point here that that the certificate, I now see it as a part of a cumbersome process militating against the admissibility of electronic evidence, and by extension, the administration of justice. And I am sure this couldn't have been envisaged by the legislature. Therefore, I am submitting here that it is high time that the National Assembly reviewed Section 84 and provided simple provisions for tendering electronic evidence to ensure speedy justice in line with the modern trend around the world. I will go to the modern trend in the course of my paper, which shall be discussed shortly. Okay, yes. So, and so very, very publicly and very boldly, I am making a case for the abrogation of Section 84 of the Evidence Act. So I shared my experience here of what happened at the induction course of the newly appointed judges and caddies. In a paper I delivered, at the end of the paper, one of the participants came to me and said that in view of what I had said and what I had written about Section 84, it appeared to her that I didn't like that section. Well, I said, maybe or maybe not. But then, what I have discovered from Section 84, when I say it hinders the administration of justice, is that some critical documents have been found to have been rejected for flimsy reasons. For instance, the requirement of putting the particulars of a document. You will hear a court rejecting a document because sufficient particulars of a computer, have not been given. And now ask, at what point does a party or a witness supply sufficient particulars? The law, our law does not state it. And so, using such as an excuse to defeat the justice of a case, I think is detrimental and very dangerous for the system. So, I have cited an example of a report published in an online newspaper here to further buttress my point, the case is about cyber stalking, and the report was that court rejects WhatsApp messages as evidence in trial. Permit me to just read what the report has published. It says, the prosecution, I have changed the names for some obvious reasons. The prosecution of the teenager, that's the teenager being charged for cyber stalking. I call the person Los Angeles, standing trial for cyber stalking with the intention to blackmail, suffered a setback at the court on Tuesday, as the court declined to admit a computer printout of WhatsApp publication presented as an exhibit in the prosecution. Then Los Angeles was on October 18 arraigned by the Department of SSS, and it was alleged to be involved in sharing of the nude video of a permanent secretary. Then Mr. New York, that is the judge, the permanent secretary is Mr. New York. Then Justice London had on October 22 adjourned the trial to November 9 to rule on admissibility of WhatsApp printout as exhibit, following the objection raised by the defense counsel, Mr. Accra, that the exhibit violates section 84, subsection 2 and 3 of the Evidence Act. At the resumed trial on Tuesday, Justice London, while admitting that the evidence, though relevant to the case, said it could not be admitted. Why? Because of disparity in the models of mobile phone used. Those are the particulars stated in the certificate. That was the basis for the rejection of a particular document that will form the fulcrum of that case. In most cases, you will find that these electronically generated documents that are in contention, they are usually the bedrock of most of the cases. And look at this now. The message through which cyber stalking was alleged has been rejected. And why was it rejected? Particulars, there's a discrepancy as stated in the certificate. So now I ask the question, why should disparity in the models of mobile phone used form the basis of the rejection of this of such a vital evidence that forms the fulcrum of the case? For instance, in the example of the case that I cited in my court, that statement of account, if I had rejected it, it means the bank will have won that case, and they will have continued to charge the man, and the man will have been made to pay the debt, the loan he took twice. So you can see how crucial it is. As a matter of fact, I was put in a very difficult position because as at that time, I had just written my first book, Admissibility of Electronic Evidence. And in that book, I stated, looking at the wordings of Section 84, that it was mandatory that certificate should be tendered. And the man cited my book before me, my lord, this is what you said. And he read what I said. And I said, okay, let me go home and come back. Before then, honestly, I didn't know any lawyer would come before my court and raise any issue on admissibility of electronic evidence. And I will not sit down there and write my ruling and give it back to him. But this one, he cited me. This is what you said. And what I said is against, in my heart already, it was against the justice of that matter. He rejected this document and the case was over. And I said, please, give me time. Let me go home. And I went home. When I returned to give my ruling, and I said, wow, I discovered that Section 84 cannot cover all cases. In fact, I came up with the principle, I formulated that principle, that law cannot command an impossibility. And Section 84, as an example, cannot command an impossibility. And it was that position, that revelation in that case, that led me to review that my book, and I devoted a whole chapter 13 of my book, Electronic Evidence, revised as to make the point that we should develop exceptions to Section 84.4 particularly. And the exception I formulated was that where somebody is not in possession or control of a computer or any device at all that to produce an electronically generated document, then it should be seen as an exception. And it gave me the greatest joy to see that recently in the case of Stanbic PLC Global Term Limited, the Court of Appeal, accepted my position and even quoted me extensively. And now, so we now have a principle of law, subject to what the Supreme Court will say anyway. But as at today, going by decision of the Court of Appeal, we now have a decision, a principle established that says where somebody is not in charge, is not in control or in possession of a computer that produced a certificate, it should be treated as an exception. I thought you were going to clap for me. I know I have done nothing about it, but it gives me a personal joy that a higher authority can recognize the principle and establish it as the law as at today. We hope the Supreme Court will see reason with the Court of Appeal. So, this is one of the reasons why I said we should rethink about our Section 84. Again, I also discovered that this Section 84 that we carry about and is giving us so much problem is a reproduction of Section 5 of the Civil Evidence Act of UK 1968. What we are carrying about today, it was in the law. We quoted it verbatim, word for word. And it is also the same thing as Section 69 of the Police and Criminal Evidence Act 1984 of the same United Kingdom. But the interesting thing about what we are talking about here is that Section 5, that is our Section 84 today, has been repealed in 1999 in UK. And that Section 69 of the PACE Act was also repealed in 1999. So, it means that it follows therefore that in 2011, when Section 84 was added to our Evidence Act 2011, Nigerian, what we were doing then was simply to adopt a provision that had already been repealed in England for over 16 years. After it has been repealed for over 16 years, it was then we were adopting it as our own law in Nigeria. And so, why was it repealed? Section 5 of the UK Civil Evidence Act was repealed following the recommendations of Law Commission, which stated that the framework under Section 5 had become outdated following the developments in computer technology. So, as Nigeria has adopted a provision that was deemed to have been outdated in UK as far back as 1995, I hold the humble view that there is a need for a similar review in Nigeria so as to address various practical difficulties that may arise while complying with Section 84. So therefore, it is not about, like the participant said, it is not about me not liking a particular section of the law, but it is about doing justice. And so I want to take you to the new trends now. So, and I cite 3 examples. The example in UK, the example in America, the example in Singapore, for you to see how the world has developed. So I begin with the United States. In United States now, courts have held that electronic data can simply be authenticated by confirming that they were produced by the adversary during document discovery. So in America, like the example of the case that came up before my court, the fact that this document has come from the opponent, it is the opponent's document. The law has been liberalized to the extent that that reasoning alone is sufficient to say that that document is authentic. Of course, it is the opponent's document. If it is not, he would not have given it to you. In any event, even if it was not authentic and he gave it to you, the court will treat it as such. So that is the level of liberality of admissibility of electronic evidence in America today. In United Kingdom, after repealing Section 5 of the UK Civil Evidence Act and Section 69 of the PACE Act 1984, they have now resorted back to the common law position. And the common law position is a presumption that any document produced mechanically will be presumed to be authentic until the contrary is proved. So if I have any electronically generated evidence and I desire to tender it in court, the court will on the prima facie take it as authentic until the contrary is proved. And who will prove the contrary? It is the one who says that it is not authentic. Again, that is the position in UK. Then in Singapore has advanced to a level that they have developed 3 presumptions in their law to authenticate electronically generated evidence. And the first presumption is that mechanical devices are presumed to be in order when they were used. That is the first presumption. The second presumption is authentication of authenticity of business record. That if it is a business record that you are tendering, it is also presumed to be authentic if it is produced by somebody who is not a party or is not part of any of the proceedings. In other words, when an electronically generated document is to be tendered, and none of you, plaintiff and the defendant, or the accused and the prosecution, none of you produce this document, and the person who produced that document is not a party in that case. In Singapore, the law is that that document is presumed to be authentic until the contrary is proven. And the last presumption, that electronic documents obtained by a proponent from an adverse party to a civil and criminal proceeding is authentic. It is, I had explaining like what happened to the case in my court. It was a document of an adverse party, and so the law presumes in Singapore that because it comes from an adverse party, it is presumed to be authentic. So I have described all this as revolutionary trends around the world that liberalize the process of admissibility of electronic evidence. And my suggestion and my advocacy here is that Nigeria must move with the world. Nigerians' experience, I pray it will not be like the Indians' experience. India is having a very serious problem with their Section 65B, which is the same thing as our Section 84. And I have cited about 4 cases. The first case there is the state versus New Delhi, versus Najot and Sadhu. In that case, the Supreme Court of India came to the conclusion that where a matter is dealing with admissibility of electronic evidence, if a certificate containing details are not filed, then it could still be admitted if there is a secondary evidence of that certificate. So the first reaction of the Supreme Court of India was not to accord much effect to their section 65B, our own section 84 of our Evidence Act. But this decision that was in 2005. Then in 2014, the Supreme Court of India in Anwar versus Bashir came up with another decision. And the summary of the decision was that it was mandatory to produce a certificate. So in the first place, it was like it is not mandatory, especially if you have an alternative to tender. The second case says it is now mandatory. The Supreme Court felt that a certificate under section 85B is compulsory for admission of electronic evidence. That was in 2014. In 2018, the same Supreme Court of India came up with another position. It was this decision that also influenced the Court of Appeal in the case I mentioned earlier, that if a party is not in control, then it should be presumed to be authentic. But again, just recently, this year, the Supreme Court of India, very shockingly to me, now came up with another decision. In Kailash and others and Arjun. In that case, the court now says the question of impossibility of getting a certificate does not exist. In other words, that you cannot say you cannot produce a certificate. And the court, let me read what I have here directly. It further held that it is incorrect to conclude that difficulties may arise from obtaining the certificate. I am not sure, with due respect, the Supreme Court of India is correct in this case, that you cannot have difficulties of obtaining the certificate. The experience in my court shows that you can have difficulty, because if the person in control of the certificate of the computer does not give you, that must be a difficulty. All right, so it was accordingly stated that if the competent entity refuses to grant a certificate, then the other person can apply to court for another to produce, notice to produce. That's the basis of the decision of the Court of Appeal, of the Supreme Court of India, to say that you can never have a problem. I have, with the greatest respect, departed from the position of the Supreme Court of India. Why? Because notice to produce cannot give you that certificate. For instance, it is not as if the certificate exists as a matter of course, unless there is a case, or you anticipate that there's going to be a case. It is not usual that you will print a document from your computer and you will be drawing up a certificate. So basically, I ask, number one, if the certificate does not exist, what order are you making to produce? That is one. Number two, where I disagree with the Supreme Court of India, notice to produce is not a penalty at all. All it does, I have cited the law, section 89 of our Evidence Act, and I have cited the case. If I give you a notice to produce a document, you are not obliged to produce it. All that the law requires is that if I don't give you that original, the secondary document with you will be accepted by the court. So now we are still talking about certificate. So where is the secondary evidence of the certificate? If you give another to produce. So it is on the basis of that that I have disagreed with the Supreme Court of India, and I want to stand by the position of their earlier decision that if somebody is not in possession of a document of a computer, then it should serve as an exception to it. So, well, Stanbic case, I have mentioned it to you, what the Court of Appeal beautifully did. Honestly, yes, Justice Ogunya JCA, and it was very clear. In that case, I can just summarize it to you. Somebody applied for loan, a bank to another bank applied for loan, and well, before such a loan will be given, they will produce a report. And in the report produced, in respect of that request, it was stated there that that bank was not worthy because in the past they had taken loan which they did not repay. And that bank said, wow, this is damaging to our business, and so went to court to claim damages. And by the time they got to court, that report was tendered. And it was admitted in actual fact at the trial high court. But when it got to the Court of Appeal, the point was raised that it should not have been admitted, and so it should be expunged. And why? Because there was no certificate backing it up. And the Court of Appeal said, no, this report, the man who tendered was not the one who produced the certificate. I mean, who produced the report. The report was against me. I am taking the report to the court. And the bank who produced it did not give me a certificate. The Court of Appeal said no. The trial court rightly admitted that document, that report. So just imagine now that if that report had been rejected because of certificate, then the case of the damages for whatever it is would have been defeated. So the Court of Appeal said no, because that certificate was not tendered, the man was not even in a position to tender a certificate. And so the Court of Appeal admitted it. I wrote a review on that decision, and it went viral. And I will continue to commend the Court of Appeal for that position. I describe it as very timely and very correct. So I hope the Supreme Court will follow, will hold on to that. Now, I just move straight. I think the second to the last part of my lecture. And that is case of Moses J. Juan and EcoBank Nigeria Limited. This case also went viral on social media recently. And what you find on social media is like a check. I don't know how many of us read that thing. ATM is like a check. They are aware. The post purported to report a decision of the Court of Appeal. And the gist of the report is that failure of a bank to pay a customer through ATM when the customer has enough money, will entitle, it's a breach of duty of care.